Good morning, everyone. We hope you're keeping safe and well. Thanks to everyone for joining today for our second ECA Coronavirus Impact Webinar. We'll be holding another next week. I'll post the sign-up link here a bit later on. You can find all of ECA's coronavirus information on our website. However, I should warn you at the moment, we are having some technical difficulties, so bear with us and we'll let you know when the website's working again. But the link, just to keep in mind, is www.eca.co.uk/coronavirus. Today we're being joined by our two regulars, our Employment and Skills Director, Andrew Eldred, and our Legal and Business Director, Rob Driscoll. We're also delighted to be joined today by a special guest, Ruth Wilkinson of Clark's Legal. Please do send your questions in to us either by Twitter at ECA Live or in the chat box on the webinar. We'll endeavour to answer all of them in the Q&As after the presentations and potentially some at the end, time allowing. Rob and Ruth, over to you to kick things off.
Thank you very much, Mike. As Mike said, I'm Rob Driscoll, Director of Legal and Business at ECA.
Hi, I'm Ruth Wilkinson. I'm a partner in the construction team at Clark's Legal, based in Reading and London.
We are going to attempt to take you through and navigate some of the commercial issues surrounding the current COVID-19 outbreak and addressing some of the big challenges that are coming through on our inquiry system, on our social media platforms and other areas. So, to deal with the big issue first, we've had some questions in advance of the webinar about this. It is the current position of the government that, certainly in England, under the Construction Leadership Council, which is a partnership between government and industry alike, sites are to stay open subject to the following criteria. And that is that Public Health England guidance is adhered to, that health and safety is not compromised, and that works can be carried out under the standard operating procedures. And you will be able to see our website for details of that. Even if our website is slightly temporarily unavailable due to technical reasons, it will be up again later. And all the information we talk about today can be downloaded and looked at in further detail on there. And the fourth criteria is that workers can travel safely and responsibly to and from site. Each of us will have our own opinion about how viable, pragmatic, and reasonable that request is, but that is the current position from government on English sites. Now, we'll come back to this issue later because we do have a section where we're addressing the issue of what some in the press and other areas are calling bullying, but certainly pressure tactics on sites that remain open, and as to the pressure about how you deal with those issues. But there are a number of key issues here which will enable you as subcontractors or sub-subcontractors to push back on any pressure to make sure that the right arrangements are in place for you to continue works where you are still willing and able to do so, or required to do so under your contracts. Some contractual risk issues to think about, and we'll cover these as we go through today. So that's what's happening with your material supplies, variations and changes under your contracts, what happens to delays and time under your contracts, how you're going to manage your labour, some of the money issues, what you can and can't claim for, site closures and whether that leads to suspension or termination. And then we're going to address the big issue about bullying, which requires you to collate and keep a lot of evidence and future-proof your business model against any claims that you didn't act properly when all this is over.
Right, so thanks, Rob. Robert specifically asked me to just talk to you all briefly about the force majeure provisions, obviously you're aware that there are provisions that deal with this in the JCT contract, and equivalent wording in the NEC contract as well. So force majeure is there's no recognised meaning in English law. It's actually a French kind of civil law concept, and it literally translates to superior force or act of God. It's common to see this amended by the parties in any schedule of amendments, and any amendment is usually intended to try and limit the scope of a force majeure provision. Whether or not a force majeure event has occurred needs to be assessed on the facts, and I think kind of helpful to look at the French Civil Code for a understanding of kind of what it means in general purposes. So it's an event that's beyond the control of a party. It's not reasonably foreseeable as at the date of the contract, that it could not have been avoided, and it prevents performance. Now, I think it's important to point out that there's no case law on the force majeure wording in the JCT forms, and as I've mentioned, it's not defined, and it's likely under the JCT contract that its meaning might be quite restricted, particularly in relation to claims for extensions of time, because there are other grounds for extension of time, specifically in relation to relevant events such as war, strikes, government actions, etc. It's also important to note that you have an obligation to mitigate any delay or the force majeure event. So that also is something that you need to factor in. I mean, I think it's fair to say that there's likely to be a significant amount of debate on the meaning of force majeure and whether it applies to COVID-19 over the coming months and years. One thing that I found out doing some research this morning, that in February 2020, the Chinese government apparently issued over 3,000 certificates saying that a force majeure event had occurred because of the COVID-19 outbreak in China. However, that's, is that enough? We still have to go back to the underlying contract to work out what actually is required by that. So moving on from, do you want to say something, Rob?
Yeah, just a question for you, Ruth. Do you think when we get to force majeure, whether it be in JCTs, NECs or bespoke contracts, then actually we'll also reach an issue where if somebody is trying to particularly protect their own business model at our members' costs, at our contractors' costs, they might start to allege that it became reasonably foreseeable that they could have mitigated the impact on the project because the COVID-19 outbreak dated back into China in December 2019.
I mean, I certainly think that's possible. I agree that this is going to be a very hotly contested area, and in fact, I had encouraged one of my clients to send a notice to their employer. This is a contractor client, explaining that they considered that this was a force majeure event, and that they thought this would likely delay the project. And they got a response very quickly saying that the client disagreed that this was force majeure. And I think we are going to see this, because everybody, I think, is kind of drawing the lines and starting to put themselves in the position, which is unfortunately endemic to the construction industry, that we are very confrontational. I mean, I think that certainly in relation to the contracts that were entered into before December last year, before the outbreak started, before we heard about the events in China, I think it was on the 31st of December, I think, they may be one category where it might be quite easy to say this was unforeseeable. I think you've got a valid point there, Rob, that for contracts that were entered into after that date, it might be parties might try to claim that it should have been foreseeable because of the events in China. But I mean, I think you'd be able to point, for example, at the press coverage at the time. I mean, this country was only interested in Brexit for many, many weeks. And I think it was mentioned on the news, but I don't think people really genuinely thought it was going to be coming here, or it was going to be coming here to that extent. But I think you're right, it is going to be a very, very vexed question, and I imagine there'll be lots of lawyers arguing about it and a lot of case law on it in coming months and years. So moving on for force majeure, and I'm trying to use the arrow to change the slides, which I was assured would work. Hang on a sec, I've done it now, I think. Nope. Yeah, frustration. Thank you. So So we talked about force majeure. There's also this common law concept of frustration. And this is where a contract may be discharged or frustrated if something unforeseeable occurs after the formation of the contract, and it makes it impossible to fulfill the contract, or it radically changes the obligation. Now, it's really important to say there's a really high threshold for frustration to apply, and you can't simply argue that it's more difficult, that it's inconvenient to perform the contract, or that it becomes unprofitable to do so. If frustration does take place, and this automatically discharges the contract, and there's legislation and common law which then steps in to deal with both compensation and recovery of monies. I think it's fair to say that there are very, very few cases of of frustration. However, there is one example that I think is relevant to just note, that there were some cases before the First World War where the government prohibition or restriction on building operations during the wartime did cause some construction projects, some construction contracts to be frustrated. There's also some other cases, again, quite old historical cases, about the cancellation of a king's coronation because of illness. So I think, frustration is certainly something to bear in mind, but there is, in the past, it's not been something that's cropped up all that much. So I think, Rob, I'm handing back to you now.
Yeah, I wanted to ask you one question on frustration, though. Even if it could be used, and 9 times out of 10, I guess it wouldn't be, if there was a force majeure option in the contract. And bearing in mind, frustration is a general principle outside the contract. Is it not the case that it leads to immediately release of the parties from future obligations, which means they can't actually make any claims for loss of profit, wasted expenditure, because the contract suddenly just stopped?
Yeah, I mean, like I said, I think my understanding is that the frustration has the effect that the compensation, etc., is dealt with not within the four walls of the contract, but by this legislation, very old legislation. I think it dates from the 40s. And I think the point to note with frustration is it is a little bit of a nuclear option, so to speak. And I think it's fair to say that what Build UK, for example, are trying to encourage, and certainly I'm trying to encourage with my clients, is that there's a dialogue between the contractors and their supply chain, and the supply chain to the contractors up to the client, about what they can do in order to deal with this situation. So looking at ways to reach an agreement as to what the consequences are going to be and what they're going to do next, rather than to simply at this stage look at trying to terminate the contract or exercise options such as frustration. I mean, I think for my part, this is something that may come into play over the coming weeks, depending where we go, but would definitely be something that would be a last resort.
Thank you. And before I jump into the next part, I think I'd add to that by saying that actually, if you look at the 2 policy procurement notes from government, which I'll talk about in a second, many of the issues arising around contracts and payments in both of those policy notes, although they touch on mentioning to contracting authorities in the public sector that frustration and force majeure exist, they encourage the public sector authorities to take a much more collaborative, proactive approach outside contractual claims. So the conversation we're trying to have on this webinar is about 2 things. One is the legal issues and the contractual issues involved, but as solicitors, it's also to advise our clients on what's best for the business. And that may not be just leveraging the contractual position. The contractual position might encourage the other party to reach a much more flexible approach, but that's where we are. So one thing before we go into the nuts and bolts of the standard form contracts here is what happens to your contracts. Now, I said on our previous webinar, I think that although most of the standard forms for our area of industry, our sector in terms of engineering services, are based on JCT or NEC, and Ruth will talk to us about JCTs in a second, we must remember that I think in 90% of cases, they are always butchered with some kind of bespoke amendments. So when you're reaching for the drawer to find the contract, if you have one, because there are some which are written on purchase orders or standard subcontract order forms, they may cross-refer in the footer to see our terms and conditions, copy available on request, or on the website, or available for inspection at our head office. You have to dig those out, standard form plus amendments, to ascertain your position as you go through this contractual challenges. And that's really the tenure of what we're talking about today, trying to do contractual audits so that you know your position. Insurance. One of the other questions that has come up is, should I be sending out people into site? What's the position there? Well, let's think normally, even without COVID-19. You have public liability insurance to stop and insure the risk of injury to the public in carrying out your works. You have employer's liability insurance. By law, it is required so that you insure the risk of injury to your employees. On this slide, I've put the SOP, that's the standard operating procedures, as well as your health and safety duties under law. They are sacrosanct, and the standard operating procedures developed by the Construction Leadership Council are there to preserve health and safety in the midst of COVID-19. Whether we have a moral or political opinion about site openings or closures, that's the position we've got at the moment. So I would say, yes, you have to acknowledge your insurance policies, stay within them, otherwise you won't be insured and you'll be self-insuring, and your insurers may walk away if you negate your insurance cover. And ask your insurers what steps they think you should be taking. If they say, we don't know, what's reasonable? What's reasonable right now, in my opinion, should be measured by the standard operating procedures. As for business interruption insurance, we've had a lot of queries around that. 9 times out of 10 or 99% of cases, those types of insurance policies exclude risk for pandemics. So you won't necessarily be covered. But don't follow sweeping statements like that. Check your policy, check the wording. You might have the other rare percent which actually do allow you to claim. But that's where we are at the moment. Notices. We're talking about time, money and payment and various things like that in the contracts. Things are fraught out there now. We accept the level of anxiety in industry. Check how notices under contracts should be communicated, and don't accept or forget that phone calls, WhatsApps, messengers, and sometimes email may not be allowed under the contract. So you wouldn't want to be denied later on simply because you sent the communication by the wrong method. Time bars and conditions precedent. Again, under standard form contracts, especially when they're butchered by bespoke amendments, you will often see sometimes reasonable, sometimes unreasonable time bars. If you don't make your claim and communicate with us within a set period, right form of communication, you lose your rights to make a claim. Check those. This is about getting the contract out, getting your highlighter, and making sure you pull out the right provisions. What's reasonably foreseeable? So Ruth and I have touched on that. We've touched on that in the sense of your duty to mitigate under force majeure. Lots of contracts, JCTs, NECs, bespokes, the whole gambit, start to talk about what's reasonably foreseeable. Break that down. Is COVID-19 foreseeable? Yes, in the sense that it broke out at the end of 2019. Was it reasonably foreseeable? Means does everybody else see it that way? And as Ruth has carefully explained, it may not be reasonable because the British public, press and media certainly didn't wake up to it until within the last month. Materials. I think the thing we're asking at the moment is check your specification. Does it say equal or approved? Because if you can't get your materials from your usual source, the place where you have priced it in order to deliver the contract, you might be under the contract be required to continue working, in which case you've got to get a secondary or tertiary source of materials. You're probably in a better place if those materials are free issue, in which case they're given to you by your client to install, and they're not your problem. You've got to look for alternative sources where you are contractually obliged to stay on site, but that may be problematic if the materials or the plant you're ordering is bespoke and you've had to pay some up front. The other thing I'd say here, though, is start to think think differently. The public sector, again, in one of the policy procurement notes I talk about later, has been told they can think outside the rule book, the normal rule book. In this COVID-19 situation, they're encouraged to think about other ways of securing cash flow within the supply chain. Things we've done in the past for clients out with the COVID-19 outbreak is put in place things like advance payment bonds, vesting certificate or advance payment agreement. And that simply says our contract price is heavily loaded with materials and plant. We don't want to bankroll this situation, especially now. Pay us for the materials and bits and pieces we've got to order for you up front. We will insure it, locate it, secure it, label it as yours in case we go bust, sign a piece of paper, which is one of these vesting certificates or offsite materials agreements, and then it's yours. And that eases our cash flow position. So that can be really useful. You need to figure out what your logistical issues are in terms of deliveries, how that's going to work with Public Health England, with social distancing. Some of the good distributors and manufacturers and everybody in this space have already gone there, worked out electronic payment systems, how to pick up, how to deliver, and how that system. So I think the key here, as Ruth said, is keep talking and make sure that you're asking both your suppliers and your clients what their COVID-19 problems are.
Right, thank you very much, Rob. So to kind of start off by looking at the position under the JCT contract. So kind of the starting point, we're looking to look at the relevant events, and these are the events that entitle the contractor to claim for additional time under the contract. So I think the starting point is to bear in mind that the contractor carries the risk for all time and cost for those matters which are within its control. For example, things such as availability of labour, materials, etc. And then it's also important to note that the cost risk usually lies with the contractor in relation to delay events, because the effect of those is normally neutral. So on that basis, they're not entitled to also get loss and expense if they're entitled to an extension of time. There are some exceptions to that, and there are some items that are also relevant matters, but those items include acts of prevention by the employer or the employer's persons, and changes and variations to the works. Now, on this particular slide, there's a list of some of the relevant events that may entitle you to an extension of time that may be relevant in the circumstances of COVID-19 that we find ourselves. The clause referencing relates to clauses of the JCT Design and Build contract 2016, and the referencing in other versions of the JCT contract may be slightly different. So just bear that in mind when you're checking the terms of your contract. And also, and as Rob has alluded to, 9 times out of 10, the JCT contract is heavily amended by the parties, and that includes amendments to the relevant events. Relevant events are either deleted in their entirety, or alternatively, further restrictions are placed on them. So I would implore you to have a look at the schedule of amendments and check what changes, if any, have been made to the regime for applying for an extension of time and the relevant events themselves. Now, I think it's also important to note that I don't suggest that you try and put all your eggs in one basket. So there's a whole list of relevant events, some of which will not be relevant to your particular project. We may have not caused or contributed to delay, but some of which would be relevant. And I think when you're looking at issuing a notice, and I'll talk a bit more about the notice that you can issue in a few minutes, think about all the grounds that might be relevant to causing the delay. So we've already talked briefly about force majeure, and that's ground number 14, clause 226.14. But there's also other ones that are relevant there. So, for example, if the sites are shut down due to government mandates, so there's, for example, emergency regulations that are submitted. Of course, we've got the guidance from government now that you have to follow the site operating procedure. Then you could look at ground number 12, which relates to exercise of statutory powers. There may also be arguably acts of prevention by the employer, who may refuse for you to go to site, who may close site down, in addition, they may delay the issue of instructions, they may delay approval of some designs, there may be changes to the works. So, for example, the employer may require that you change the method and sequencing of your works. The definition of change is quite wide. So just think kind of broadly about what possible grounds you could be claiming under. Now, also, you need to bear in mind in terms of the relevant events that you're under an obligation to mitigate the effect of any delay. So you have to use best endeavours to ensure that the effect of any delay is mitigated. And you also have to ensure that you give the notices in accordance with the terms of the contract. Now, when we talk about giving a notice under clause 224, which is in relation to getting an extension of time, unless that clause has been amended, then it is thought that that clause is not a condition precedent, i.e. that if you fail to make a notice within a particular time frame, you're not stopped from you're not prevented from making a claim for an extension of time. But sometimes in the schedule of amendments, that can be turned into a condition precedent. So you need to check that really carefully. The clause that talks about giving notices says that a notice ought to be given forthwith, i.e. immediately, when it's reasonably apparent that there's going to be a delay to the completion of the works, to the completion date. And it sets out the specifics of what that notice needs to include. You need to include a description of what is happening, the particular events in question that are causing delay to the works. You need to identify those specific relevant events that are listed in the contract as well. And so I think we've covered all of that. I think the one really significant point here, and I know that Rob has already talked about this, mentioned it briefly, is it's absolutely vital that you keep really good, accurate records of what you're doing on site. So the notice that you give under clause 224 is not just you give it once and then you kind of forget about it. It requires you to update that notice when you get further information, when you're able to predict the extent of the delay with more certainty, when further things happen that may alter the situation. So you need to be kind of constantly monitoring it and giving an update. And also you need to be able to evidence that the obligation is on you claiming that delay to be able to prove cause and effect, to prove that what you say has happened and it's had the effect that you say that it has. And the way that you need to do that is to make sure that you've got really good paper records, so records of progress on site, records that you maybe had tried to mitigate your loss. So maybe correspondence that you might have with a supplier, for example, showing that you tried your best to make sure that you could get goods and materials on site for a particular time, but you were told repeatedly that they just simply weren't available. Records of what the condition on the site was at a particular day. And I think certainly in the current circumstances, it would be very wise to be keeping day-by-day records of what works are being carried out on site, what people are on site, etc., etc. And this is all the type of materials that will be used by lawyers and by any delay experts, in the coming months and years in order to kind of help you prove your particular case. Was also flagged on this slide about termination, and I think we have to accept the unfortunate reality that it's possible that some projects may get terminated altogether for various reasons. And I think it's important to note that there are two grounds that enable you to suspend works. They are force majeure and statutory powers. And if works are suspended for a continuous period of more than 2 months, which is the standard period stated in the JCT contract particulars, but can be increased and is usually increased, then it entitles the contract to be terminated. And I think it's also important to note that under the JCT contract, any notice of termination cannot be given unreasonably or vexatiously. So when termination has been looked at as an option, you need to consider whether that test, that not to be given unreasonably and vexatiously, has been satisfied. Rob, do you have any questions for me before we move on to NEC?
I don't think so. I think one of the things that has come up is about whether you're relying on COVID-19 itself, or in both NEC, which will be my section in a second, and Ruth's, whether actually a site's been closed on you by the client or the main contractor. In that case, I think you're looking at there's a ground under the relevant events which give you time and money, whereas force majeure under the relevant events only gives you time, if I'm correct, Ruth.
That's right, yes.
The employer or a main contractor under the subcontract version impeding or preventing you from performing your obligations is an event which allows you to make the claim for time and money. So if the site's closed on you, that's where you go. Sorry, Ruth.
No, that's fine. I think that's a fair point. Like I said, I think you just need to kind of think quite carefully about what's actually happened, and what would be the best basis for you to be able to say that it gives you the best entitlement to time and money, if at all possible. And I think also, if you are getting instructions, if somebody is telling you can't come to site, you need to go home, if they're telling you if they just ring you up and telling you that, I really recommend that you get something in writing, and whether that means that you have to write to them to confirm the details of a telephone call or a WhatsApp message or something, make sure that it's recorded in writing who gave you that instruction and when they gave you that instruction, so that you've got something to later to point at, some physical evidence to point at. I haven't got anything else to say, Rob, if you want to move on.
I'll take them through to NEC. For those who work on public infrastructure projects and a lot of public sector work, the favourite contract of choice is NEC. There's version 3 and version 4. It's worth pointing out before we dive into the deeper clauses that there are various options to price a contract in the first place. A and B, you've got our fixed price. C and D, our target. That means anything that goes over gets shared. Anything that goes under gets shared. It's a kind of pain gain system. And then E and F are based on profit and overheads, and the employer pays the costs. And that works the same in the main and the subcontract versions. So really, if you're looking about claims or price changes, C and D will already recognise those, so you don't need the clauses in there. A and B is where you'll need to make claims if you're going to have to make them and protecting yourself. And E and F is a much more flexible and innovative arrangement anyway. But I'd footnote what Ruth said, which is actually you may be having these contractual conversations, you should also be having the collaborative commercial conversations. It may be the contractual conversations that leverage a more diplomatic dialogue because nobody wants to go there. Right, where we are in NEC is there isn't quite a force majeure clause as such. Section 60 outlines compensation events, but there is this section in 60.19 and 91.7. It's the same test for both. One applies about whether you can claim, and compensation events, to translate the language here, is the one list of events that give both time and money, whereas JCT uses relevant events for a list of time and relevant matters for a list of money, direct loss and expense claims. So if it stops a contractor completing the whole of the works by the completion date or the date on the accepted programme, neither party could have prevented it, and an experienced contractor would have judged this issue to be so small in terms of its likelihood of occurring that it would have been unreasonable to allow for it, then you can launch a compensation event claim. You will probably pass that test for COVID-19 in terms of its disruption to the sites and the materials. But as Ruth said, you need to clinically go through the test and prove each element in order to satisfy it, not simply put all your paperwork in a leverage folder and say, there you go. It's about being very methodical and forensic about these things in order to protect your business model as you go forward. If the delay is more than 13 weeks under that very same test, it will leave the parties an ability to terminate. But again, have constructive commercial dialogue. Doesn't have to be purely contractual. There may be other grounds, as Ruth described under the JCT, where the project manager or the main contractor comes in and wants to issue instructions to make changes, which in JCT language is variations. They may change the sequence, the dates. That's clause 61.4 there. We try to put the references on the slide so that you will know roughly where to go. As Ruth said, some of them change depending on which version of each contract you're in and how heavily amended they might have been by bespoke amendments, but they will be broadly the same and direct you to the right sections. If site access is hindered, so site's closed or temporarily shut down, 61.2, changes or breaches by employers or main contractors or other trades, you've got 60.118 there, and delays in your access and other points is 61.3 and 5. The important thing about NEC is it's different. It's not the usual type of JCT black and white rulebook. If you don't get an instruction, you can confirm what you think should happen back to the project manager or main contractor, and they will go through the process of reconciling that instruction. But if you don't make that claim within 8 weeks, you will be locked out of making any claims. This contract also has clauses which talk about operating in the spirit of mutual trust and cooperation. It was a contract designed by engineers for engineers, so it's less legalistic, less black and white. It has a risk register, which is supposed to have identified the risks. I would suggest that the parties proactively add this to their risk register and figure out a way. They might want to change the pricing structure from fixed price to target and negotiate the pain gain sharing arrangement. You should early warn. You're asked to early warn about all matters which might affect the delivery, disruption and progress to the works. So you should make sure those clauses, those notices are sent in line with the contract provisions about how notices should be sent. And then you should check the Z clauses. Z clauses are bespoke amendments. So they are the clauses at the back, butchering the clauses at the front, if you like. And I know from working on London Underground contracts, for example, who use NEC, they have lots of Z clauses changing the original standard form of contract in a different way to protect their business model. There are options to recognise change of law, but it only reduces the price, doesn't increase it, so they may not be of use to you. And my last point on NEC is remembering that the contract does recognise the programme, but it recognises a programme and expects it to be revised at intervals. So stay on top of the administration and the bureaucracy within this type of contract. It is more bureaucratic than JCTs and does expect consistent communication between contractual parties, which right now people are getting quite heated and anxious about. So I said I would address the issue of being pressurised to maintain your site existence if the site hasn't been closed by the client. If the client or the main contractor has chosen to shut the site, that is their decision. And we've spoken about JCTs and NECs about what you want to do in terms of your paperwork to protect your business model moving forward. The way I would recommend people approached being told to stay on site is to confirm that, of course, you wish to work proactively and consistently with your clients and continue to comply with your contractual obligations. However, I'd like you to think about leveraging your position under the contractual machinery so that you do record keep, evidence your position, and require them to confirm that they are able to comply with my first slide, which says they can comply with Public Health England guidance, ensure that whatever workers they've got can travel to and from the site, because it might be just outside the site gates, comply with the standard operating procedures. That's your best reference point. And then if they can do that and sign off on it, which will pause them and their potential aggression or assertiveness towards you in terms of the contractual behaviour, and give you an opportunity to think. I've had a recent instance where they were under just this pressure the employees were not particularly enthusiastic about going back to site, and eventually, having ensured that the SOP were complied with, they were given an entire floor to themselves to maintain social distancing and work within the guidelines. So they were much more happy about being able to manage the health and safety risks to their workforce and ensure continuity of work. So that's about the overriding pressure that's coming down the supply chain to continue delivery. I wanted to touch on the government guidance. I did so the other day on the webinar. So how government works, I just wanted to highlight that we at the very top, so our very top management are sitting within the Construction Leadership Council COVID-19 task force to try and make representations on your behalf to influence and bring the issues to the government's attention so that industry and government in partnership, and I would say the government in their construction unit are doing an absolutely awesome job about disseminating information as quickly as possible to the market through organisations such as ours. And all of our information is available on our website. Government cannot tell itself what to do. It roughly accounts for 35 to 40% of the demand in construction industry as the public sector. If it told itself what to do, it would be in breach of competition rules. So what it does is it issues policy procurement notes. Notes that go out to government, all procurement departments, bar a few, people like MI5 and those that have special treatment, and telling it how to operate. So we have two policy procurement notes, 0120 and 0220. The first says, in essence, that the procurement rules that public sector must adhere to are suspended and they can make fluid, flexible, quick, agile decisions once they pass certain tests in those rules in order to ensure continuity of public sector services. And that will be relevant to the built environment and the engineering services sector as they move forward and ensure that hospitals do not fall over due to building issues, schools continue to operate, and all other infrastructure that underpins the continuity of public sector services. The best news is PPN 02/20, which talks about the public sector's ability to ensure the business continuity of the supply chain. So that's them being able to advance to pay you, potentially release retentions to you early, to get you to ensure you keep billing, that if you're on a call-off or a framework or a strategic alliancing contract where you get paid against KPIs, key performance indicators, you can continue to do that, regardless of how your service has been disrupted. They can redeploy you to more useful parts of the public sector. So that's both public procurement policy notes are going to be really useful to any of you that work with the public sector, directly or indirectly, to open up those collaborative conversations so that you can continue to have service continuity and commercial cash flowing into your businesses. As of today, essential workers, key workers, critical workers still remain those that can send their children to school, nothing more. It's a heavily misunderstood term in the media, and as of yet, they have not been highlighted as having any more significant treatment other than those workers who are still required to go to work due to the nature of their jobs, and therefore their children can still go to school. HMRC has its Time to Pay initiative, which has been around for many years, helped some people through the Carillion crisis. They are slightly overwhelmed at the moment, but I have had reports of some members getting positive arrangements where their tax bills can be delayed, whether it be VAT. There is also the announcement from the government about self-assessment being delayed. And I'm sure my colleagues will cover the self-employed. I just wanted to focus on CBILS, which is the Coronavirus Business Interruptions Loan Scheme, slightly, and highlights that the misunderstanding around this is that government has offered to guarantee an overall cap with each of the 40 retail banks who have been asked to give special lending to businesses that need it, up to a maximum of £5 million per loan. So government's guarantee is to the bank, not to the person taking out the loan. The banks therefore still have to do due diligence as they always have done. Anything under 250,000, they're not required to take security. Anything above, they are at liberty to still do that, even though they can't take the principal property if it belongs to another, i.e. another person not taking the loan. In summary, I'd like to highlight that you need to be doing your contractual audits with clients, subcontractors, suppliers, making sure that your notices are sent in accordance with the contract. Continue to communicate both contractually and commercially and collaboratively. Build your evidence portfolio, check your insurance provisions, and talk. If you're looking for our website, if it's not available now, it will be later. It has lots of guidance notes on all of these issues here, and my colleagues can direct you to that as you need to.
One from Justin Wright, who asked this earlier on. Our operatives work on street lighting works as a single person working, carrying out routine maintenance. The job by definition keeps them in isolation. However, the company, a leading energy company, has ceased all works except essential and emergency works, including their own. Can they seek compensation from the client?
As long as the works, I think as long as the works have stopped by the client's orders, that may be a slightly bespoke. If it's street lighting, I would probably guess that it would be something based on NEC. They can largely stop the works on us. There may be a suspension clause allowing them to, or they might want to do it unilaterally. Either way, that can form the basis of the compensation event. It shouldn't need to be a force majeure if they have ordered the stoppage of works. If they've ordered the continuation of the works because it's essential or critical, then it's observing the isolation, they should be fine.
Okay, thanks, Rob. This one's from Callum Wilmot. Where do we stand regardless of force majeure if the main contractor has decided to close the site rather than pulling guys off our site?
Ruth, do you want to take that first?
Yeah, I mean, I think if the main contractor's taken a decision to close the site, then that would be, if you were the subcontractor, that would be either an instruction, either the basis of an instruction from the contractor that site was to close. It could potentially be a suspension of necessitating a suspension of your works. It could be an act of prevention. So I think they would be all grounds that you would need to have a look at and see whether they were covered within your contract to entitle you to either get an extension of time or in some circumstances also claim loss and expense. It just depends on the terms of your contract.
Okay, thanks. Next one from Ruth Devine. If there is a clear contractual compensation event, what is the basis for Tier 2 claim preparations? Is it just costs for demobilisation/remobilisation?
I'll go first with the in-house lawyer's view, and then Ruth can tell me I'm wrong. There is a methodology that says follow causation. Put everything down that could be possibly part of your claim, but don't be fraudulent, and then follow it through to make sure that whether it be because the client has shut the site or because of COVID-19, health and safety risks or whatever else, you can match the cause to the loss and the costs involved. So I would suggest you put all your costs down and evidence them to make sure you've got documents backing them up. That may not just be invoices or whatever, that could be diary notes and other contemporaneous materials as well. But Ruth, do you want to come in from a private practice solicitor's perspective?
I mean, yeah, I agree, Rob, with what you've said. I mean, I think the other point is to kind of, you need to have a broad think about what costs you are incurring, because even if the works have been suspended, it might be that you're still incurring kind of preliminaries, for example, in terms of the cost of welfare facilities or insurance, managerial staff, site security, plant hire costs. So I think you kind of think quite broadly on a contract by contract basis what services you were providing, and what of those services are going to be paused, and what of those services need to continue for whatever reason. Because it may be that you want to continue to provide some of the services on the basis that you want to try and mitigate the position when works can restart. And if you just literally put everything on hold, you might not be able to remobilize as quickly as the contractor would like you to do so. And I know it's slightly off point because you're talking specifically about the cost side and the claim that you'd put together. I mean, I agree that you should be starting to put together what that claim is, but at the same time, there's an obligation to continue to have these commercial discussions and to try and work out a way through this and to try and mitigate any losses that you may have and your ability to restart.
Okay, thanks, Ruth. One final question and then we'll wrap up. So this is from Gary Christian. We are a security company that carries out routine servicing mainly to intruder alarm systems in domestic and commercial premises. I have concerns about visiting these premises with the risk to employees and customers. Service engineers could visit up to 8 premises a day, so the potential to catch and spread the virus is high. Should we be carrying out the routine maintenance?
Well, this is unfortunately one of those positions where that decision is ultimately yours, not mine or ECA's. Typical lawyer's answer. However, what I would say is that if you're continuing to do that, monitor the health and safety risks, put in place the appropriate measures. There is this evolving thought process within the industry that, like hospitals and schools, power, gas, heat in people's residence is becoming critical. But obviously you have a duty towards your employees, which you've also got to manage that risk and make sure they're in an appropriate place. Practical issues, ask the household. Does anybody in the household have had symptoms? Have they been to any infected areas in the globe? Ask them to verify that. Some of the deliveries in the retail space online are doing that right now. So I think you have to continue the service delivery, but in a very carefully managed and closeted way in that sense. There was something that rocked up that I could see on the chat feed earlier, which goes back to this issue of directors. It is specifically noted in the CBILS, which is the Coronavirus Business Interruption Loan Scheme, that sole traders and small micro businesses come within that stratosphere, and therefore they can access those loans if they don't fall within the job retention scheme, the furloughing system, or other government support initiatives.
Okay, thanks very much, Rob. Thanks to all our presenters, particularly to Ruth for being our special guest today, Ruth Wilkinson from Clark's Legal. That's much appreciated. We'll be back on Tuesday at 11 a.m. for our next webinar. Rob and Andrew will both be around for that with our special guest, Stuart Young from the Department of Business, Energy and Industrial Strategy. Thanks again for listening. If you want to find out more, please visit www.eca.co.uk/coronavirus. Thank you.